So today's topic is of preventive detention laws. And I think this is a very, very vast topic. It would actually take me weeks to really deal with this topic in a in-depth manner. So what I'll try to do is try to give you a bird's eye view on what is preventive detention, the various laws, and the way the judiciary has dealt with preventive detention laws and what checks and balances the judiciary has attempted to add. And then lastly, I'll conclude with where we should go from here. So I think what is preventive detention is the first question we must answer. So what one must know is that there is no authoritative definition in Indian law, whether by a judgment or by any act, that defines preventive detention in India. The origin of this term, preventive detention, was actually used to explain two very old British laws, the Defence of the Realm Act. There were provisions in the Defence of the Realm Act and the Emergency Powers Act in 1939. These provisions were emergency provisions that had been used during wartime to keep England, they were used during wartime in England to keep people who were friendly with enemy nations under check. So essentially, during World War II, if you were a Nazi sympathizer living in England, then these provisions were used to put you in preventive detention during the war. However, what is pertinent to note is these were emergency provisions. So once these wars were lifted, once the wars were over, these provisions were repealed and they were lifted. However, the best way I would describe preventive detention to you is by quoting the Supreme Court in Anukul Chandra Pradhan. The object of detention is not to punish a man for doing something, but to intercept him before he does it and thus prevent him from doing something. I think the best way to understand preventive detention and what it entails is to look at it in juxtaposition with arrest, which is actually punitive detention. So when you compare the two, in an arrest is made for either committing or being suspected of committing a crime. Preventive detention, on the other hand, is mainly used to prevent a person from committing a crime. Under arrest, you have several constitutional safeguards that have been written in under Article 22(3) of the Constitution. You have to be produced before a magistrate within 24 hours. You have a right to a legal attorney. You have the right to be informed about the grounds of your arrest. Under preventive detention, those safeguards in 22(3 as well as the CRPC don't necessarily apply to you. After that, there is one positive that if under arrest, you are disqualified under Section 62(5) of the Representation of People's Act from voting. So if you're arrested, you cannot vote. However, people who are detainees under preventive detention are given the right to vote. What we must really know before we go into a deep dive is that most liberal democracies do not have preventive detention laws anymore. Preventive detention laws are looked at as draconian. And in fact, in the field of international law, there are provisions that are specifically there to curtail the ability of countries to make prevention detention laws. Primary among them, for those who have some knowledge of international law, is the ICCPR, which stands for the International Covenant of Civil and Political Rights in 1967. So Article 9(1), which is the article which deals with right to liberty, freedom, and protection from arbitrary detention, really attempts to curtail member countries from making preventive detention laws. However, India, when ratifying this section, we raised a reservation, while ratifying the section, we raised a reservation to 9(1), stating that it will be subject to the provisions of Sections 3 to 7 of Article 22 of the Constitution. And Article 22, Sections 3 to 7 are the main articles that deal with preventive detention laws in this country. So let's move now to a history of preventive detention in India. Provisions of preventive detention, they existed way prior to the Constitution and the bringing of the Constitution. One of the first acts which had provisions for preventive detention was the East India Company Act back in 1784. Thereafter, even the Rowlatt Act, which is the Government of India Act, also had provisions for preventive detention. This was in 1919. However, the first complete act, the code which dealt with preventive detention, which had provisions for detention, had procedures for preventive detention, would be the Bengal Prisoners Regulation Act of 1818. Under this act, a person could be put in jail simply for being suspected of criminal intent. That was the benchmark that you had to meet. In fact, post-independence, the term preventive detention finds its name, it finds its place in our constitution. It's actually the most ironic because the founding fathers of our constitution are probably the people who suffered the most under preventive detention laws under the British, and still they gave it constitutional sanctity under, and that too under part 3 of the constitution, which deals with fundamental rights. So out of fundamental rights, an exception was carved out for preventive detention laws. So I'll start with Article 22, which is the main article that deals with preventive detention. Article 22 is best understood by Article 22.1 and 22.2, which lay down the rights for a person who has been arrested and detained. And thereafter, you go into Article 22.3 and 22.4, which then carve out the exception for preventive detention. And thereafter, you go into Article 4 and Article 5, which deal with certain rights that are given to detainees. And then after that, you go to 22.6 and 7, which deal with the exceptions within the rights that are given to detainees. So I'll start by reading out this article in extensio, because I feel this is a very, very important article for us to understand the base of preventive detention laws in India. So to start with Article 22, the heading is protection against arrest and detention in certain cases. Under Article 22.1, no person can be arrested unless he's informed of the grounds of his arrest and he has the right to consult a lawyer. And every person who has been arrested under Article 22.2 has the right to be produced before a magistrate within 24 hours. And no such person can be detained beyond this period. So this is the basic rights that are given to any person who has been arrested in this country. There are equivalent provisions in the CRPC also. However, under 22.3, an exception is called out in relation to preventive detention. So Article 22.3 reads thus: to any person who is arrested, or nothing in clauses 1 and 2 shall apply to any person for the time being who is an enemy alien, and B, to any person who is arrested or detained under any law providing for preventive detention. So 1 and 2, which were the basic rights that are given, are now under preventive detention laws, are not guaranteed under our constitution. However, we come to our 22.4 and 22.5 that do provide some limited kinds of safeguards for preventive detention, detainees who are facing preventive detention laws in this country. So under Article 22.4, no person can be detained for a period of longer than 3 months unless his case has gone before an advisory board that is comprising of high court judges or persons qualified to be high court judges, and they have deemed it fit to hold a person beyond 3 months. Under 22.5, a person has the right to be told about the grounds for his detention as soon as may be, and he has a right to make an opportunity to make a representation against such detention. So there is some form of audi alterum partem that is read into 22.5. And the Supreme Court has interpreted this, that not only is his right to make an interpretation and representation, but the order rejecting this representation must show an application of mind and be based on judicial principles. However, although 22.5 and 22.4 do lay down certain safeguards, unfortunately, the very next article, which is 22.6, carves out an exception under 22.5 and says that if there is some information that is against public policy, then even the grounds may not be necessarily given to a detainee. Similarly, under 22.7, an exception is carved out of 22.4, stating that the maximum period of 3 months after which the advisory board has to approve your detention, the government may make laws and circumstances under which the maximum period of 3 months can be somewhat increased. So what one can really garner from here is that although the Constitution, and especially Part 3 of which deals with fundamental rights, provide us with extensive rights, the founding fathers of our Constitution felt that they needed to create a niche for preventive detention, and that under preventive detention, your rights as under Article 21, under Article 22 would be reasonably curtailed. And the reasons I will come to now. So let's deal with the preventive detention laws in India. So the first preventive detention law in India, which was a state law, is Madras Suppression of Disturbance Act. Before I deal with this, I should also point out that under the Constitution, there are both the union as well as the state can make laws which deal with make preventive detention laws. The union list under Schedule 7, List 1, Entry 9 holds 3 reasons for why preventive detention laws can be made. One is for defense, foreign affairs, or the security of India. Under the concurrent list in Schedule 7, List 3, Entry 3, preventive detention can be made for reasons dealing with security of the state, maintenance of public order, or maintenance of supplies and services essential to the community. So now going to preventive detention laws in India. As I'd already mentioned, the first law was Madras Suppression of Disturbance Act, but I don't want to delve too much into state acts because they're very state specific. I want to deal with Central Act. So the very first preventive detention law was the Preventive Detention Act of 1950. Now, in fact, Sardar Patel, when he introduced the bill in Parliament, said, and I quote, "I have spent many sleepless nights thinking about this bill." It's important to understand the historical background in which this bill was passed, because India at that time was a brand new concept and a brand new country. This was the 1950s. We just had a very nasty and brutal experience of the partition. We had seen what can be done if people are making vitriolic speeches. There were many factions within India. There were religious factions, cultural factions, linguistic factions, and all of them were pulling separate ways and wanted to claim independence. So this act really was brought forward at that time to protect the integrity of India and to ensure the security of the state. However, under the Preventive Detention Act, there was a sunset clause, which meant that this act itself would die after every 2 to 3 years. It would be repealed and it would have to be revived by Parliament. And under Clause 11A of the Act, a person could be kept in custody on suspicion for up to 12 months. The Preventive Detention Act was introduced in 1950. It remained in force till 31/12/1969, and thereafter it was repealed. So this is the very first Preventive Detention Act in India, Central Act. After that, we come to the very renowned or notorious, I would rather say, and mostly talked about Maintenance of Internal Security Act of 1971. So this act lasted from 1971 and was repealed in 1977. This was largely used and to some cases abused during the emergency. And this is largely known as the Indira Gandhi era. And it was used to jail thousands of dissidents, including renowned politicians, lawyers, thinkers. Atal Bihari Vajpayee was put into prison. Arun Jaitley was put into prison. Lalu Prasad Yadav was put into prison under the Maintenance of Internal Security Act. And compared to the Prevention of Detention Act, which is the earlier act in 1950, the powers of the government had increased and the safeguards that were there in the act itself had been reduced. So this act started in 1971 and went on till 77. Why did it get repealed? Well, 2 things happened in 1977. Firstly, Indira Gandhi declared elections and she lost very badly. It was the end of the emergency and the Janata Party came to power. And one of the very first acts of the Janata Party was to repeal the act of the Maintenance of Internal Security Act because it had been largely used to suppress dissidents and suppress members of their own party. After the Maintenance of Internal Security Act, another act which, well, is not a Preventive Detention Act, but has provisions for preventive detention, and I feel it's necessary to talk about, is AFSPA, the Armed Forces Special Powers Act 1958. This is still in force. So the Armed Forces Special Powers Act 1958, it initially came into force to control areas in the Northeast, predominantly areas of Nagaland. There was a lot of unrest in those areas. Those areas did not necessarily, there was a lot of unrest. There was a grave security situation in that area, and they weren't necessarily adhering to this concept of India, and they didn't want to be part of India. So under the Act, I'll just give you a brief outline of how the Act works. So under Section 3 of the Act, the government has the power to declare any area as a disturbed area. Once an area has been declared as a disturbed area, the army, usually this is the realm of the police to ensure the security of a place. However, after order has been made under Section 3, the army can then administer the area. And the army is given given wide powers under the area, and the provision under which preventive detention provision would be section 4C, under which an officer can arrest without a warrant any person who is about to commit a cognizable offense, and he may use any such force that is necessary to effect the arrest. So the benchmark is about to commit, similar to other preventive detention laws. So these were the first two. MISA and Prevention Detention Act of 1940 has a historical context. AFSPA is still being used now. It's still in force in Kashmir. It's still in force in the Northeast. And now we come to the act that is the most predominantly used and widely used act in India today, which is the National Security Act of 1980. So the National Security Act of 1980 gives powers to the central government and the state government to detain persons on the grounds of public order and security of the state. Section 3 is the portion that deals with preventive detention, and you will mainly find this in almost all preventive detention acts, that section 3 really is the act that deals with preventive detention. The notable sections in this is section 5A, because it says that the grounds for detention are severable. So this means that if I'm a detainee and I've been given grounds for my detention, and let's say the grounds are 1, 2, 3, 4, and 5. Let's say even if what used to happen earlier is, let's say if 2 and 3 do not apply to me, I can apply to the courts. I can say that there is no application of mind that is being used. However, under section 5A now, the law is that the entire detention order cannot be vitiated on the fact that one ground shows lack of application of mind or is vague. If any ground, the test is if any ground shows application of mind, then my detention order is legal. After that, section 8 states that gives a period of between 5 to 15 days to inform the detainee about the grounds for detention. And I think this is something which we really must think about, because we have to think of it from a regular person's, from an aspect of a regular person. When someone is picked up and when someone is put into preventive detention for 5 to 15 days, he may not even know the reason why he has been put in. So he's just been put in, he's completely cut off, and for up to 15 days, the government doesn't even have to inform him about the reasons why he is in jail. And the reasons why he's in jail, this is something which is dealt with over several international laws as being one of the basic rights that is given to a prisoner, is you're told why you're in jail and you're allowed to make a representation. Anyway, let's continue with the National Security Act. Under section 13, the maximum confinement is up to 12 months. And however, under section 14A, there are circumstances which the government can state for keeping a person for longer. And under section 11.4, this is a crucial section. Under section 11.4, when a person goes before an advisory board, a person has no right to a legal practitioner. So I'd like you to keep these few sections in mind, because when we deal with the judgments and how the Supreme Court has interpreted these sections, then you'll be able to cross-link some of this. What is also important to note is that under the National Security Act, usually every year we're given crime records, and we can see how many people have been arrested, how many people have been arrested under what act, how many people have been arrested for murder, crimes related to sexual offenses, crimes under the Prevention of Domestic Violence Act. But under the National Security Act, no data is released as to how many people are detained. Then after that, we come to the several other acts, which I'm just going to mention and briefly touch upon, because I feel like these are very specific acts and don't necessarily warrant so much time. So one is the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, which is also colloquially known as Kofi Posa. This is mostly used for checking smuggling and foreign exchange related activities. Under section 3 is the main section under which the act confers powers on the government to preventively detain people. And also under section 8E, once again, there is no right to a legal practitioner. After that, we come to the Prevention of Black Marketing and Maintenance of Supply of Essential Commodities Act. Once again, section 3 is the predominant section. We come to the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. Section 3 once again is the empowering section. Also in CRPC, we have section 151. This allows a police officer to prevent a cognizable offense, to pick up someone and put him under preventive detention. However, section 151 of CRPC is very different from these other laws, because within 24 24 hours, the police officer must present him before a magistrate. So under 151 of CRPC, there are many checks and balances which aren't there under the above mentioned acts. Then also what is relevant to note is that there are several state acts. Every state has its acts in which follow preventive detention provisions. There is the Maharashtra Prevention of Dangerous Activities, Slum Lords, bootleggers, drug offenders, and dangerous persons, and Video Pirates Act. There is the Kerala Antisocial Activities Prevention Act 2007. Under this act, if you are known to be a gunda or a rowdy, then you can be put into preventive custody for a period of, again, 3 months before you have to go before an advisory board. So in India, essentially, there are several acts, both at the state level and at the central level, that kind of work together and form the basis of the preventive detention laws in our country. Now, what is pertinent to note is how has the Supreme Court dealt with this? Because at the end of the day, the Supreme Court is the final check on the arbitrary power of the executive. And we must see what are the provisions that the Supreme Court has tried to read in and what is the stand taken by the Supreme Court in several of these acts. So I think if one had to read only one judgment on this act, on all of preventive detention laws in this country, and had to get an understanding, then the most important judgment will always be A.K. Gopalan versus State Madras. This was a 6-judge bench of the Supreme Court. There was a dissenting judgment of Justice Fazal Ali, but 5 judges of the Supreme Court laid down this judgment. I'll give you a brief history of this judgment first. A.K. Gopalan was a communist who had been already in custody in jail from 1947. In 1950, when he was already in custody, he was served a notice under the Preventive Detention Act, which he thereafter challenged via Article 32 directly in the Supreme Court, claiming that his rights under Articles 14, which is right to equality, Article 19, and Article 21 had been violated. The constitutional in A.K. Gopalan versus State of Madras, the Supreme Court, the 5 judges held, they upheld the constitutionality of the Preventive Detention Act. However, they held Section 14 of the Preventive Detention Act, which dealt with the fact that even the grounds need not necessarily be communicated. They held that part was unconstitutional and violated, and they struck that down on the basis of the doctrine of severability. However, A.K. Gopalan is important to note not just from a preventive detention perspective, but also as to the approach of the Supreme Court while dealing with our fundamental rights, specifically under Article 19 and Article 21. 2 major points need to be known about A.K. Gopalan. First is that how the judges dealt with Article 19 and Article 21. So an interesting argument was made before the Supreme Court. The argument was like this, that yes, under Article 21, my liberty can be taken away by a procedure established by law. And a Preventive Detention Act is a procedure established by law. However, under Article 19, there is no such provision. There's no such question. There's no such writing of procedure established by law. My rights of movement, etc., have been curtailed under Article 19. So the Supreme Court held that Article 19 and Article 21 were mutually exclusive, and they operated in different fields. This is known as the individual silos theory. So it said that Article 19 would not apply to a law affecting personal liberty, to which only Article 21 would apply. A law of preventive detention would not have to meet the touchstone of Article 19, but however would only meet the touchstone of Article 21, wherein personal liberty could be curtailed through a procedure established by law. Secondly, this term, procedure established by law, was differentiated from due process of law. So before I go ahead, I'm just going to read Article 21 so you guys so you can get an understanding. Article 21 reads like this: no person shall be deprived of his life or personal liberty except according to procedure established by law. So what the Supreme Court held in A.K. Gopalan is these 2 terms, procedure established by law, is very, very different from the terminology of due process of law. Due process of law is something that has been brought to us from American jurisprudence. And due process of law means that one can go into the fairness or the justifiableness of the law that is curtailing my liberty. So under Article 21, as it stood during A.K. Gopalan, if there was a law that could curtail my liberty, as long as that law was applied to me, I couldn't claim I could be arrested. But however, under the due process, so how American jurisprudence looks at it, they say that not only must there be a law, but that law must be fair, that law must be justifiable, and there must be principles of natural justice read into that law itself. So unfortunately, at the time of A.K. Gopalan, 5 judges held that this concept of due process did not exist under the Indian Constitution. The Constituent Assembly had specifically used the words procedure established by law, and hence nobody can read in due process of law. However, it is very important to note that this concept was thereafter overruled in R.C. Cooper versus Union of India, which is a judgment, a bench of 11 judges, which held that no due process of law can be gone into, and any law which curtails the liberty will have to meet the touchstone of arbitrariness, will have to meet the touchstone of natural justice, and all these principles will have to be looked at and can be looked at despite there being a law that has been passed by Parliament. So this was A.K. Gopalan versus Union of India. Thereafter, we come to the next judgment, which is Khudiram Das versus State of West Bengal. This is a 4-judge bench. The citation is 1975 AIR 550. So this was again a writ petition under Article 32 of the Constitution for habeas corpus, challenging the detention of A.K. Roy, who was a sitting member of Khudiram Das, and under the Maintenance of Internal Security Act. So under this judgment, the court stated that the court will not sit as an appellate authority over the advisory board. When I refer to advisory board, I'm referring to the advisory board under Article 22(3) that must any preventive detention law, which is wherein a person is detained for a period of more than 3 months, his advisory board has to approve the same. So in relation to that advisory board, there was a challenge raised to how the advisory board had come up with the conclusion that that person should be kept in preventive detention. And what the court held was that the court cannot go into the decision making, but the decision making process. So the court will not sit as an appellate authority. It will not look into the materials that were before the advisory board. It will only look into if there was any material or if there was sufficient material. But the actual decision making will not be gone into. So it will look, in short, it will not question the decision, but will question the decision-making process. The very next judgment is, again, a very important judgment under preventive detention laws. This is A.K. Roy versus Union of India, 1982 Supreme Court 710, AIR 1982 Supreme Court 710. This is a 5-judge bench of the Supreme Court. And this raised the question of whether an ordinance also classifies as a law under Article 21. Because, as I said, procedure established by law. So this was raised in the historical context of the National Security Ordinance 1980, which was a precursor to the National Security Act, which we've already discussed. So under National Security Ordinance in 1980, sitting member of Parliament, A.K. Roy, was detained by the Dhanbad district magistrate on the ground that he was indulging in activities that were a threat to public order. Now, various members of Parliament filed petitions with the contention that the president issuing an ordinance is an impairment of parliamentary democracy of a country. And there was a need to define and circumscribe this ordinance-making power of the president. So I'll explain to you in short what this means. Is that one was National Security Act, which would have to go through Parliament, which would have to be ratified, would have to go through the Rajya Sabha, would have to go through the Lok Sabha, and therefore become an act. What happened in this case was, to circumvent this entire procedure, an ordinance was issued by the president. And under that ordinance, Mr. A.K. Roy, who was a sitting member of Parliament, had been arrested. So the question was that can, in this manner, the president circumvent the parliament, make an ordinance, use that ordinance to arrest members of parliament, and what would be the legal sanctity given to that? So a key question was whether the word law in Article 21 include an ordinance. And the court found that yes, an ordinance is a law under Article 21, and it does fall under the category of procedure established by law, and hence ordinance is as much a law as well as an act. Secondly, the court found that the court looked into the ordinance making power and said that yes, ordinance making power must exist. This is a power that is existing during a time of when the parliament is not functioning or is unable to function, and as an emergency power, the government of the time must have this ordinance making power with them. One of the positives that came out is that although the one of the challenges is that there should be a right to legal representation, and this is a constitutional right. And while the court found against this and said that there is no right of legal representation, there's no constitutional right for legal representation when it comes to preventive detention. However, the state cannot put up lawyers before advisory boards to argue its case unless it provides the same right to detainees. So what was happening is, as a detainee, when I went up to an advisory board, I was denied the right to a lawyer, but the state was using lawyers to argue their case. So the court found that this would be a violation of Article 14. Either I would have to be provided with a lawyer and the state have a lawyer, or both of us would not be able to have a lawyer. So there must be a level playing field. And also, the Supreme Court said that the detainee would be able to take the help of a friend who in truth and substance was not a legal practitioner. So some other person could make a representation on their behalf, but not a legal practitioner. We then come to the judgment of Rama Dhondu Borade versus V.K. Saraf. The citation for this is 1989 3 SCC 173. In these words, the words "as soon as may be" were interpreted by the Supreme Court. So the Supreme Court held, and again, I'll repeat 22.5. I'll just reiterate 22.5. 22.5 deals with the right to that the grounds of my detention must be told to be as soon as may be. But as soon as maybe was found to be a very vague statement. And what the government at times it was found was doing was it was delaying on this. So what the Supreme Court held was that the detainee has a constitutional right to make a right under Section 22.5, and that the authority must apply its mind and dispose of the same within reasonable time. And also that the detainee must be informed of the grounds of his arrest as soon as possible. And if there is any delay, this delay must be explained. And an inordinate or unexplained delay would vitiate the order. So I'll just read paragraph 20. I'll quote paragraph 20 of this judgment. True, there is no prescribed period either under the provisions of the Constitution or under the concerned detention law within which representation should be dealt with. Use of the words "as soon as may be" occurring in Article 22.5 of the Constitution reflects that the representation should be expeditiously considered and disposed of with due promptitude and diligence, and with a sense of urgency and without avoidable delay. What is reasonable dispatch depends on the facts and circumstances of each case, and no hard and fast rule can be laid down in this regard. However, in case the gap between the receipt of the representation and in its consideration by the authority is so unreasonably long, and the explanation offered by the authority is so unsatisfactory, such delay would vitiate the order of detention. So friends, this is what I would say as the top 5 constitutional cases that one should read. Now, I think it's very important to draw some conclusions. I've given you guys the data. So I would like to leave 5 conclusions or 5 takeaways from this talk. So the first conclusion is that preventive detention laws are relics of the past. These laws were primarily made to be used in England and in other countries during wartime to curtail internal dissent because of the peculiar situations of war. These days, they don't exist in the UK, they don't exist in the US, and most liberal democracies do not have such laws. These laws have stayed and thrived in India due to the several historical and political factors that I've mentioned above. Secondly, these laws, although they were meant to be used to promote the security of the state, what has happened lately and what one has found is that they're being used mainly for the government or the executive of the time to establish a greater control over society. So whenever the government feels that it needs to impose its hand on society, that's the time when these laws have been used and utilized the most. Not necessarily at times that we're facing an external threat or there is a security. Often at times, this is being used to suppress domestic dissent or deal with domestic issues that have nothing to do with larger issues affecting India. Thirdly, in relation to judicial oversight, one must know that the problem with preventive detention laws in India is that they're structured in a manner by which judicial oversight is limited. So when you are arrested, there are several laws, there are several articles in the constitution which give you certain number of rights so that you have a bare minimum of rights that are granted and are given to you. But however, preventive detention laws, by their very structure, by the act itself, they seem to eliminate judicial oversight. And even the little judicial oversight that does exist, the problem is that the delay that it takes, the time that it takes for one to file a habeas corpus petition, for one to have it heard, to get a final order is so long that often if the executive is trying to misuse these laws, the ultimate purpose of keeping a person behind bars for a long period is ultimately achieved. Because if I'm in jail for a period and it takes me 11 months to get a judicial order in my favor, then that purpose has already been satisfied, regardless of whether it is correctly I've been detained correctly or incorrect. And to give you an understanding of this, I mean, I'm quoting an Indian Express article here. Between January 2018 and December 2020, there was an Indian Express article that reported that out of the 120 habeas corpus petitions in the Allahabad High Court, 94 of them, in 94 petitions, the Allahabad High Court quashed the detention orders. So that means that's approximately a hit rate of 80% of all detention orders during this 2-year period that was introduced in the Allahabad High Court were found to be improper and quashed. And preventive detention laws amongst all the states are being mostly, it has been found, are being misused or misutilized in UP. And until 2021, in 2019, these are just facts that I'm giving you, over 139 people had been NSA had been invoked against 139 people, and out of this, 76 were for cow slaughter, and 13 were for people who had actually participated in the CAA protests. So one can see that there is a gross amount of misuse that these preventive detention laws can be used for by the exec. Now the question is, if these laws can be misused, why doesn't the government do anything about them? Why doesn't the executive do anything about them? And this has got nothing to do with which political party is in power. But the simple answer to that is, once any government is formed, they find these preventive detention laws as a useful tool to deal with dissent, to deal with people who are bringing up civil rights issues, to manage them and circumvent the judicial process. So that's it, guys. That's my talk.
During COVID-19, there were some cases of house arrest concerning the situation. So can these types of arrests be classified as police custody or preventive detention?
No, so this is not preventive detention. House arrest, this is, I think you're talking about the Vivan case. House arrest was also dealt with, if I'm not mistaken, Gautam Navlakha's case, and it's considered arrest. You're still arrest. So it's very different from preventive detention laws. It is still considered arrest, and it is considered arrest by police.
To requests you to shed some light on detention laws for juveniles.
For juveniles, so juveniles will mainly be covered under the Juvenile Justice Act. And as far as I'm aware, I don't think there are any preventive detention laws for under the Juvenile Justice Act. In fact, even detaining a juvenile, there are several provisions of the Juvenile Justice Act, if you go through, which say that a juvenile cannot be detained, a juvenile cannot be kept in a regular jail. So there is no preventive detention, and Juvenile Justice Act operate in two very different fields. And I don't think there is anything under Indian law which can be used preventively detain a juvenile.
Can you state the alternatives for emergencies if the statute is someday repealed entirely?
What they're referring to is that what would happen in a situation in which, if these laws had been repealed entirely and you face a situation of emergency. So, well, three things. First is that we must remember that, let's say we're in a situation of an emergency. At that stage itself, if the executive feels that they need a preventive detention law, they can go and enact one. They can pass an ordinance, and that can give them these extraordinary powers. So these powers do not need to be there during peacetime. That's the first answer I'll give you. Secondly, we have several provisions of the CRPC. We have several provisions under which you can be arrested in any case. So, and this is exactly the answer I gave. The first answer I gave is exactly how this law was used in England. So in England, once World War I was declared, when World War II was declared, to prevent people who were Nazi sympathizers from stirring up domestic trouble, the law was passed and these people were preventively detained.
Habeas corpus available against preventive detention. I think they just,
Yes. So predominantly the writ that you would go under is habeas corpus. Predominantly. So out of the judgments I cited, I think all 5 would be habeas corpus petitions. 4 out of 5 would be habeas corpus petitions. Thank you, everybody.